The Set P fraud, settlement P form. This is the new fraud that has come to light. I was just talking to a client last week, and that's where I came to know. As in last year also, I have made several videos on people trying to buy time on fee waiver applications, FLR applications, etc. The problems that they have been facing. Fee waiver, after fee waiver applications, you cannot switch into any other points-based application. But I don't know, some individuals have advised them, legal reps or whoever that is, and they have ruined their situations. Even FLRs, people filed FLRs and then they were put on immigration bail, and with immigration bail they cannot switch to any other visa from inside the UK, any points based visa. So now new thing that I have seen, last week I was talking to a client and this came to light. I had heard this before, but I saw the form page and etc, so I know that this is happening now. So I don't know, some legal rep or consultant or whoever advised that her to buy time. So another buying time game this has started. Remember, Home Office doesn't like buying time applications. I'll come to some suggestions what is possible, but buying time is not that Home Office likes. But every time these visa consultants or whoever lawyers, they come up with some solutions. Previously they tested the fee waiver, then the FLRs, and now this new thing, SETP, settlement application. That form is for a refugee who has lived in the UK for 5 years and they apply for settlement. The reason they are using this form or suggesting this form is because it is free. Every time students, skilled worker holders or graduate holders, they always go to lawyers and they try to ask for the cheapest option. So I think that is what I'm thinking, why they have started filing this application, which is not going to give you anything. It's the reason that they've selected this form is because it's a free application for refugees, and ILR application is free. So just they wanted some application to be filed to get you section 3C leave, but that doesn't help. It rather hurts your situation. Firstly, this is a frivolous application in the eyes of Home Office. You can file this, but it will ruin your life. Similarly, now once Home Office starts staying this pattern, the way they saw FLRs, and finally they came up with a solution, will refuse them and put the person on immigration bail. Whether it is as per the rules, laws or not, they have just taken that stance. They've spoken to policy teams, their policy team, and that is the stance that has been advised by their policy team, saying go for it. If you really want to challenge your immigration bail on your FLR, etc., go to the High Court and get it from a High Court judge. So they have taken a very hard stance. So in a similar way, this SETP abuse has started now. So this I've got to know, I'm not sure how much deep it is really, how many really applications I've filed, but this has come to me, hence I'm just advising everyone that if anyone is advising you to file this, don't file this to buy time. It will ruin your life as soon as Home Office gets to it, or even obviously it will definitely be refused, but once Home Office starts refusing them with some effect, with some negative impact on you, for example an immigration bill, which they started doing on FLRs applications last year, and they have been doing that quite, they pick up the FLRs very quickly and they put you on immigration bail. Even in there have been instances which have been reported on the YouTube channel, and people have sent me their refusals on WhatsApp and emails also, where I've seen even before attending the biometric appointment. I know everyone tries to buy time by delaying that biometrics for that 42-day period or etc. But even before the biometrics, people have been stopped, refusals have been sent, and they have been put on immigration bail. So I have seen such situations also. Home Office, I'm not sure what is the level of intensity or how badly Home Office is coming against these SETP applications, but they will slowly get to it and they will come up with a similar solution, I think so. So SETP application, it's not for you. It's a settlement for refugees. Don't file this application if anyone is recommending you. It will just ruin your situation. What is the best you will get? You will get maybe 3 months or so, or maybe on a higher end 6 months. I don't think that client, they filed around January. Yeah, maybe on a higher end 6 months you may get on that application. Yes, you may get section 3C leave, you may get a right to work for some time. Your current rights may continue. If you are a skilled worker, your rights will continue. It won't help you because you won't be working with your employer. Usually that will be the case because you are not working for your employer, and that's the reason your permission is curtailed. So you can, if you are a skilled worker, it will not even help you. You'll just get a legal status for about 6 months, but once it is refused, you may not be able to work as well. Your dependents may be able to work, I'm just taking different scenarios what I can think of. Skilled workers, because you are only allowed to work for your sponsor, and the 20 hours also you can work only if you are working with your sponsor. So if you're not working for your sponsor and you file this application, nothing, you cannot even work in the UK. You can't work with your employer because you're not working for them anyways, and the 20 hours is not allowed because you're not working with your sponsor. That's the first part. For skilled workers, yes, students may get some time, whatever that is, till this application is refused, a right to work or so, and maybe graduate holders, yeah, because you have full rights to work. Either students out of term time and graduate holders anyways have full rights to work. But this will ruin your situation. A frivolous application will be on record unless you just want to stay in the UK for this period, try to buy time and then leave the UK and never come back. Then never file this application. That's my wise advice. So I've covered this, and Home Office may start putting people on immigration bills. That's what I do think. As soon as they see it's a frivolous application, you are not on refugee leave, but still you're filing this settlement application, which is obvious. Uh, Anyone can see that and say that it is a frivolous application. If you do that, they may start doing that. But even at this stage, if they are not putting on immigration bill, definitely you do have a frivolous application on your record, and after that there is not much hope as well. Anyway, people always try to do this because I remember I was speaking with a client. She wanted a skilled worker sponsorship or something, and the employer was trying to file for sponsor license. There are different solutions for that. I'll just get on that. But then, just to buy time, if you have something coming afterwards, yes. If you are just going to file a student visa, it may not help you subsequently, because there is something in the immigration rules for student visas. Your date of application, yeah, not going very technically, has to be within 28 days. Your co-start date has to be within 28 days of the end of your previous permission. So that's where everyone fails. I have spoken to many individuals who wanted to switch to student visa. Almost no one was able to switch. So don't try buying time if you are going to get a student visa after this buy time game. Now, coming to the buying time game of graduate route holders. I know you have a receipt, whatever it is, your results are delayed. The problem is, this is where Home Office. So we have tried several applications on this for the graduate routes buying time. In the first round, I think last September, not September 25, September 20, September 20, January 2024. Yes, that batch when we tried, almost I think about not much applications. Not everyone is doing so many pending results applications. I think all of them, about 5 or so we did, and all of them were approved, where we subsequently gave the result. We asked the Home Office to keep it on hold, and then after that we sent the results. That was okay around Jan 24 batch. Around September 25, yeah, September 24 onwards last year, and January 24 also, any applications that have been filed, there is about 70% chances of success. So out of 10 applications filed, around 7 were approved, 3 were not approved, where the Home Office caseworker strictly went by the immigration rules, and they said, so what is a pending results application? We file the application before your student visa expires. Summarily, I'll just put in this. I've made some case studies last year or so. You can watch those videos. So if your visa is going to expire today, let's say student visa, and you still don't, your degree is not awarded, it is delayed either for results or whatever that is, you have a receipt and all. Home Office was okay initially around Jan 2024, but since last September and the January of this year batch, January 2025, they have started refusing applications, saying that on the date of your graduate route application, you had not passed the course. Your university had not conveyed to us that you have completed the course successfully. So this was the problem, where I've seen out of about, yes, we filed about 10 applications, 7 of them were successful, exactly similar cases, where we sent the results subsequently within about 60 days after the date of filing the application. Within 60 days, not like 6 months or so, only about 2 months time or so. So that is possible, but remember, Home Office, even after considering that, some caseworkers, The ratio has been higher. 7 of the 10 applications have been approved. 70% chances that they have been approved. 7 caseworkers decided to approve the application, even if the course completion or whatever the graduate degree was given to the applicant after the date of the graduate route application. But 3 caseworkers decided to go strictly by the rules and they have refused the applications. So remember that that is also, there is a chance of failure in that. So this is just, I am giving an example. What is the time, what is the option instead of that buying time applications, whatever ones I'm talking of set P in this one, there is a pending results application also, which we have tested and it has worked. We have asked for discretion 7 times out of 10 we have got the discretion. It is your choice whether you wish to do it, but always do it through immigration lawyers who has experience doing it. You can book a consultation with me. Consultation is always gold, as I told you. Link is in the description. Okay, so coming to the buying time game for skilled workers. So why do skilled worker, when I say you may be on any permission as of today, but your next application is going to be a skilled worker application. That is the example I am taking. You may be a student, you are a graduate holder, or you are already a skilled worker. So, but you are going to apply another skilled worker application, either changing jobs or you visa curtailed or any reason for that matter. The next application you're going to file, so your permission is ending today and you're going to file the next application. The employer is ready and they may be at different stages. Maybe the employer has not filed a sponsor license, or they are just filing it now, or they have filed it but they have a license also, but they have filed for an allocation of an undefined certificate which takes 18 weeks. And priority services, it's quite very hard to get it. It's only 100 slots in a day and you have to send the email at a particular time in the morning. Not everyone gets it. It's quite a mess over there. So priority is not guaranteed for everyone. So assuming that is happening, employer is willing to sponsor you. They either have a license and have applied for a course, or they don't even have a license, they are just applying for the license. So along with the license you can also file. So this one is quite, has a very high chances of success. We've done it every time we have got it. So it's called as, we named it as pending certificate of sponsorship. So let's say your current permission, whatever that is, it's ending today. You file your skilled worker application but without a cause, and we explain the home office, we give them any evidence that we have, maybe the sponsor license reference number if a sponsor license is applied, or a letter from the employer saying we want to hire this person, we've applied for cause, something to show the home office that yes, there are efforts going on to assign a cause to this individual. With that, we request home office to keep the application on hold, and we have asked home office many times. We've tried this over the last 5 years. I've seen, even we used to do this in the tier 2 general area also before skilled worker. So every time it has been, we have had 100% success rate. Every time the caseworkers have agreed to keep the application on hold, because they do understand that, for example, if a sponsor license application is pending, then it is their problem. It takes about 8 weeks for a standard processing. It is their timelines, their delays. That's the reason it takes about 8 weeks or so. For that, they have been okay till now. They have not refused applications as invalid, because the rules do require you to provide a certificate of sponsorship issued within the last 3 months of today, the date of application of your skilled worker. But they have relaxed that rule, kept the application on hold. We have subsequently provided the costs and they have approved the application. Many times we have done that and never we had a refusal. This also, if you're trying to do, always do it through an immigration lawyer. It's a critical one. The home caseworkers have the option to declare the application invalid, refuse it, do whatever, because you have not given the important piece of evidence. It's a points-based application. They can refuse it. Remember, if you want advice for your situation, consultation is always gold. Yes, book a consultation with me. Link will be in the description. So I covered students. If you are going to become a student, don't do this. Don't even try this SETP or any pending applications. You won't get anything. You should ideally go back and apply for an entry clearance. If your next application is going to be a graduate route application, and for whatever reasons, resits and all of that, resits are so common. I know I speak to so many individuals on this and advise on this matter. So if you have not got your degree award by the date of submission of your graduate route, there is this pending results, I'm just naming it, there is no such name, you can google it, you won't find pending results. I'm just trying to give a word, pending results graduate road application. Yes, we have had success, but home office has also refused applications. So I'm telling you clearly, 7 out of 10 have been successful, I think in the last January batch. Yeah, so that's how I remember roughly, and 3 have been refused. And if they refuse, there is not much recourse. Remember that there is not much recourse. Even if you file admin review, which may take 12 months, on those 3 applications which have been refused, there is not much hope, because they have refused as per the rules. The only thing is they have not exercised discretion in your favor. You cannot do anything. You cannot say why the others have been approved. We've had exactly similar situation also, where 2 friends who they are from the same university, same course, exactly same, they had something, the result was delayed. Very similar matter. Even they got the results on the same time. We sent the results on the same time. One caseworker approved that, another caseworker refused it. Exactly same. Even they have the same course. I remember that fact, because I remember one applicant, he came to us, he filed his application and he told his friend, and then his friend contacted, and the subsequent week we filed his application. They were just back to back. But because they were from the same uni, same course, exactly same situation, but one was approved and one was refused. Okay, so remember that it is on the discretion of the caseworker, because if they go strictly by the immigration rules, they may refuse it. But with pending certificate of sponsorship, if your next skilled worker application, if your next application is a skilled worker application, yes, and you have an employer who is willing to sponsor you. These are 2 requirements for this. If you don't have an employer, just buying time will not help. You won't go anywhere. And don't file the ZP, or even buying time may not help. If you file the ZP, you may just get 3 to 6 months till the time it is refused. After that, you will have to leave the UK. So there is not much hope. So this is what I wanted to cover. This is a new fraud that has come to my attention. Settlement P. And yeah, if you do get value from this video, do subscribe, like this channel. And if you did like this video, and you want to know about another video which was released on the topic of employers recouping costs. This is a very important topic. Employers, they try to take the costs of the sponsorship, whatever sponsor license fee, cost fees, ISC, immigration skills charge, or anything for that matter. uh, what are the implications of that? What is the current status? Watch this video over here. I will link it over here. It will give you what are the current problems with that recouping of costs that are going on. And thank you very much for watching this video.